All right, why don't we get started? I'd like to first thank our sponsors from this week, um, Lloyd and Lynn Chazen, sponsored earlier in the week for yard sites, and Charlotte and Joby Lichtman Eisen, sponsored earlier in the week for yard sites. I hope I didn't miss anybody, but I just wanted to say shkoyach and thank you, and may the neshamas have an aliyah. All right, let's get started with really what's I think is the last discussion that we need to have for now when it comes to inheritance. We could spend a lot more time on this, but I just wanted to touch on one more issue, which is now that we've learned that the Torah has a specific method of designating what happens to my assets after I die, and then it's divided among my sons. And my firstborn, if I have a firstborn son, he gets a double portion. What am I supposed to do in order to ensure that I can leave a portion for whether it's a wife or a daughter or charity in such a way that I can ensure that my wishes are going to be fulfilled? And we learned earlier in the week that there's a concept of mitzvah l'kayim divrei hames. So if I give instructions to my heirs to give a certain percentage of my assets to tzedakah or to their sister or to their mother, then there is a mitzvah upon them to listen. But nonetheless, technically, the money still belongs to them. And so b'di'evet, if they choose not to listen to rabbinic authority, there's nothing within my power that I can do. So obviously it would be advantageous for us to find a mechanism to ensure that my heirs will fulfill my last wishes before I leave the world. One of the ways to do it is very simple, is to create a living trust and to put all of my assets into a living trust, and I can live off of the trust while I'm alive. And but that trust no longer belongs to me. Technically, it's already been segregated, and it no longer is subject to the laws of inheritance. And so that's what a lot of people do. But what I'd like us to look at is a document that was drafted a few years ago by the Beis Din of America. That's the Beis Din of the RCA in New York. And it provides you, and I sent this out earlier to our chevra on the WhatsApp earlier in the week, but I want us to read it together so that we make sure that we understand it. And it's over here. I'm just bringing it up. There's a whole, it's a few pages called the halachic will. Okay? Now, I want to first preface this by saying that Rav Moshe Feinstein was of the opinion that once you lay down your wishes in a will, then using the principle of Dina de Malchusa, that the law of the land is the law, the heirs have to listen, and it's considered to be a legitimate reapportionment of your estate, even according to halacha. But most poskim do not accept Rav Moshe's, surprisingly, most poskim do not accept Rav Moshe's statement just flat out. They say that it is always better to do something explicit in your will documents to ensure that you are conforming to halachic standards as well. Because technically, since a will is only enactable post-mortem, at that point, once you've already passed away, the Torah has already given all of your sons your estate, and your daughters and whoever else you'd like to have be a part of your estate, halachically is not entitled to those assets. They don't, because it doesn't belong to the decedent anymore, right? Ein kinyan la'achar misa, the Gemara says you cannot make transactions after you're already deceased. So this is an article from Rav Mordechai Willig, who's one of the major poskim of the RCA. And you may have seen his name being circulated during coronavirus because there were a number of issues where he was consulted and his wisdom was very much relied upon. Together with Rabbi Herschel Schachter, those were the two poskim for the RCA throughout this whole pandemic. And he writes this was done maybe 20 years ago, this document, or maybe 15 to 20 years ago, I would guess. And he writes as follows: the monetary laws of the Torah, as recorded in Choshen Mishpat, have unfortunately been largely disregarded even within the Orthodox community. And of course, as you know, that's the reason why we have this year. Litigation between two Jews before a secular court is prohibited, and one who extracts money to which he or she is not entitled under Torah law is guilty of geza, which is theft or robbery. The principle of dina de malchusa dina, that the law of the land of the law, does not apply when two Jews are involved, for if it would, as the Ramah says, all the monetary laws of the Torah would be batul, null and void. While in many circles Choshen Mishpat is de facto batul, the observant individual resolves monetary disputes only by compromise or in a din Torah before a beis din. And I'm not going to get too much into that. We have to talk about using beis din responsibly, and the lack of confidence that some people have in beis din today is based upon past history with the experience with batei din. But when you have a responsible beis din, and you have people who are from and want to work according to the rules of the Torah, that's what they're supposed to do. However, there is one area of monetary law which affects everyone, even the majority who succeed in avoiding disputes and litigations. This is the area of Yerusha. According to the Torah's laws of inheritance, a man's sons, if he has any, are his sole heirs, each getting an equal share, except for the Bechor, who gets a double share. In addition, the halacha provides for the widow, who can exercise one of two options. She can receive food, clothing, and shelter from her late husband's estate indefinitely, losing these rights only if and when she remarries, or she can receive a lump sum payment of the ksuba, which currently totals over $33,000, which is not a lot of money, especially by today's standards. The halacha also provides for single daughters, entitling them to food, clothing, and shelter until they mature, and a substantial dowry as well for their marriages. It is a common practice to leave a will by which a person's estate is divided according to his own wishes, and not in accordance with the halacha that he just mentioned above. However, a secular will has no halachic validity, since it takes effect after death, at which time a person has no halachic power to transfer his possessions. Therefore, a person or charity designated in a will has no halachic right to the property bequeathed to him, and may take it only if the rightful halachic heirs agree to give it to him. And that's, of course, because they have a mitzvah l'kayim divrei hameis, but they can say, we choose not to regard that halacha. Obviously, leaving such a will could easily lead to gezel, and therefore it is a violation of lo yuchal levakir. That those words mean that the beis din or the Jewish community cannot allow a man's estate to be misused, even though this attempt has no halachic validity. In fact, the only will recognized by the Torah is one made by a very sick man, shchiv meira, where he's on his deathbed, like we explained before, in which he divides his property among his sons in unequal or specified shares. Of course, a man can give a gift to whomever he pleases, and can even make it conditional upon a lack of retraction until his death, which would effectively give him full control in his lifetime. However, a halachic kinyan is required, but basically what he's saying is create a trust where you create a gift that is rescindable. That would be one mechanism. You basically say this document creates a rescindable gift to so and so, which can be revoked at any time before my death. However, a halachic kinyan is required. The simple of which is sudar, which is effective for both real and movable properties. A kinyan sudar is where you make a transaction by exchanging an object for consideration with the other party. So, for example, if Reuven is giving Shimon a gift from his estate, Shimon gives him a handkerchief, Reuven lifts it up, and that affects a transaction of the gift that is in question. It is not effective, however, for property acquired after the gift is made or for a person's outstanding loans. While written loans, such as bonds and bank accounts, can be transferred, there are logistical difficulties involved. In addition, a division by percentage, which includes future acquisitions, cannot be achieved by means of a gift. Hence, dividing one's estate by means of gifts is effective only in limited cases. Our rabbis therefore devised a different method to enable a man to arrange that a person who is not a halachic heir will receive a part of his estate. This method was widely used when it was customary to leave one's daughter half a share. And that was typically what was done in one's estate. This was done in the Talmudic period, where a man wanted to make sure that his daughter had something, but he wouldn't give her the same amount as a son. He would give her half of what he would normally leave to a son. And that's why it's called chatzi zachar. It's called chelek chatzi zachar, the portion of half of a male. The procedure is as follows. The man writes a note of indemnity, obligating himself to pay an enormous sum of money to his daughter. And that sum is usually larger than the whole amount of his estate. Okay, it is stipulated, however, that if his sons will give his daughter a certain percentage of the estate, then the obligation is null and void. Upon his death, the sons will perforce give her entire estate as a creditor, meaning that she now has this promissory note that basically states that if you give me a percentage of the estate, then this promissory note is null and void. If you don't give me a percentage of the estate as a gift, so then I can use this promissory note to collect the entire estate. This arrangement can be implemented to bequeath, in effect, a share of one's estate to as many people or charities as one desires. It can also be made conditional upon a lack of retraction during one's lifetime. Since secular law probably does not recognize such an obligation, and since often it cannot be assumed that the heirs will abide by Torah law, it is suggested that a regular will be drawn up together with an accompanying document containing an halachically valid will with the same net results. This would avoid the halachic problems which would otherwise face the person who writes the will, the ultimate heirs, and the lawyers involved in the estate. And so essentially what he's suggesting is write up your normal will that you would write up with a lawyer that conforms to Canadian law or whatever country you're living in, right? And then add a simple clause that is an attachment to that legal will that's been drafted by your lawyers, which contains just one short statement that he's explained in brief over here, and that is to say that all of the above conforms to halacha in the following mechanism, where I leave my daughter the value of my entire estate if my heirs do not fulfill the wishes that are contained within this trust document, the will document. So he writes as follows. Form of the halachic will. So Jewish religious law does not recognize the validity of a will. Except for unusual circumstances, one cannot arrange for his estate to be divided in a manner different from Torah law. However, by creating a conditional obligation, one can achieve the same net result as that of a will and other government laws in a way which conforms to Torah law. A person who writes a will should obligate himself to pay a sum of money greater than his total assets. It is stipulated that the obligation is retractable and is not payable until one moment before death. So it's a conditional gift that I say, I hereby designate so-and-so, usually it's a daughter or it can be a friend, who will receive, let's say, the total value of my estate is maybe, let's say, $5 million. So I say, I'm giving him a gift of $6 million so that he can collect from my entire estate. Therefore, the obligation has absolutely no effect during one's lifetime. If one wills his entire estate to one person, for example, his wife, he should obligate himself to pay her a sum of money greater than his total assets. In such a case, paragraph 2 in the obligation form below should be omitted. We'll see what the obligation is. If the will includes many persons, the obligation is made to the prime beneficiary or several beneficiaries. In this case, it is further stipulated that if the Torah heirs carry out the terms of the will and other government laws, then the obligation is null and void. The obligation becomes effective when the form below is executed and delivered to the beneficiary, or any other party, such as a rabbi or a Jewish attorney, who receives it on the beneficiary's behalf, even without the beneficiary's knowledge. So therefore, all you have to do is attach this to your will documents and have your lawyer take possession of it, and that creates the kinyan that creates the gift to the person that you're naming. And so the obligation, and so this is really all you need, is just what you see on the screen is all you need to attach to your will. And it states as follows: I, the undersigned, hereby obligate myself to, and you can list whoever you want. You can say your wife or your daughter or your friend, the sum of, and let's say you put in $6 million, effective immediately, but not payable until 1 minute before my death, on the condition that I do not retract this obligation at any time prior to my death. All the property which is mine at that time, both real and personal, should serve as security for the payment of said obligation. I hereby stipulate that my heirs, as defined by the Torah, shall be given the option of paying the above obligation. So you're creating a debt, you're creating a gift which is larger than your entire estate. So your heirs will be totally wiped out as option A, or in lieu thereof. But option B is of carrying out the terms as specified in my last will and testament, and in addition, carrying out all transfers of property upon my death, which are considered non-testamentary transfers in according with the laws of the state of, and this is for the United States, so you put in the state of New York and the state of California, whatever. If my Torah heirs abide by the terms of my will and aforementioned state laws, then the above obligation is null and void. The above obligation is undertaken by a kinyan suitor in a based in chashuv, or a proper means of transaction in an important Jewish court. The above condition is made in accordance with the laws of the Torah, as derived from Numbers chapter 32, and then, signed. Okay, so that's really all you need to, if you were to do this, there are some attorneys, some lawyers who will question this if they're not familiar with Jewish law. And I know that out of Chuck Wagner's office, he is very involved in this kind of activity. He put together a whole article questioning, certain aspects of this particular method. But I've always used this method because it's the cleanest. It is in conformance with what's brought down in the poskim as far as what you can do in order to obligate your heirs to fulfill the terms of the will. And it doesn't require you to completely, restructure your will in such a way that the lawyers don't understand, because they always have a way of wording the will in such a way that they know that it'll be upholdable in secular court. And this way, you're sort of avoiding any requirement for them to be familiar with halacha. All you have to do is just include this little piece. So that's what we recommend that everybody do when they prepare their trust and will documents. Creating a living trust, from what I'm given to understand, also accomplishes this objective, because it puts all of your assets into basically into the hands of a different entity from yourself, and therefore your estate is effectively divested using a legal mechanism. But it depends upon how much control you have over the trust. It could be argued that if you have full control over the trust, then it's still in your possession al pi halacha, and therefore it's always better to include this little piece over here that we're talking about. Okay, questions, comments? Now, if you notice, Rabbi Willig had said that you can give all of your assets as a gift to your wife. That always remains an option, and there are people, as we mentioned, who leave everything to their wife. And it sort of depends how you structured your assets during your lifetime. If your wife was your partner in all of your assets during your lifetime, so then it seems that that's legitimate, because you own everything in partnership with her anyway, and you've given her that gift, so to speak. Although you should still probably do this if you're going to do that, because there could be some poskim who say that your wife doesn't legally act as a partner during your lifetime, because according to the rules of the Gemara, anything that is owned by a wife really halachically belongs to the husband exclusively. The husband has exclusive control over his wife's assets, unless they're completely segregated and that she earned them on her own. So it does get a little complicated, and that's why we think it's best if you sign this. Okay. Anything else? I'll also show you, if not, I'll show you one more document.
Rabbi, I just want a question that I'm still not really clear about is, in many households, I think I may have brought this up before, the wife could be bringing in much more money into the partnership, into the household, and she is maybe the main bread earner, or there could be various other financial aspects that she's bringing into the marriage, etc. So doesn't that get a little murky here because of that?
It does, and a woman has a right to say, even according to Talmudic law, "Eini nizonis ve'eini osa." I forego all of your halachic requirements to provide for me, and I will provide for myself. A woman does have a right to say that, and she can therefore keep all of her assets for herself. It all depends on the arrangement during the marriage. If a woman earns her assets, she does have a right to remain in control of those assets, because they never came to the husband to begin with. But let's say they have a joint bank account, then I guess they have to arrange that they have a partnership, which is not in the traditional convention of the Torah. I'm not sure I don't think that they need necessarily to have a specific document that says that. But again, because it's a bit murky, it's always better to have a clause like this. At least, a man should have a clause like that, and a woman should have a clause like that as well, also in her will. In other words, I guess your lawyer will tell you how to structure it if he's preparing separate will documents for both a man and a woman. Especially if you're dealing with a second marriage, it's quite common for a husband and a wife to have two separate will documents, because they're going to be leaving money to different people. And they have a right to do that. They have a right to keep segregated accounts for themselves if they have to, if they have to take care of two different parties of interest. So it does get more complicated. And that's why you should sit down with the lawyer, tell him you want to make sure that you include this clause at the end, just as an attachment to the will document, in order to be able to ensure that according to Jewish law, your wishes are upheld by your heirs. There have been cases in the United States, I don't know about Canada, where in the frum community, where heirs have contested a will based upon Jewish law. And there was recently in our own shul, so a couple came to me. Her mother had recently passed away, and she was the mother had left the daughter a significantly larger amount than she had left the son, and the son decided to take her to a beis din. And the basis for taking her to a beis din was the fact that he argued that he was entitled to the entire estate because it was one son and two daughters. And so you want to avoid that situation. You want to avoid the situation where you are creating the potential for strife after you leave the world, because an unscrupulous child can make up any argument or can rationalize any argument. Now he could say, well, in the will documents, mom or dad left you much more than they left me, but that was because you manipulated mom and dad and you convinced them that you were entitled to more. And therefore, I'm going to take you to beis din, because in beis din, at least, they will uphold my rights as the son to get everything, and then we'll have to end up compromising. See, so that's the reason why you want to avoid any kind of confrontation post-mortem, by just making sure that it's clear in your will documents that you are cognizant of the halachic considerations, so that your heirs won't have the ability to try and use the beis din as a tool to change the apportionment of the estate that are according to your wishes. Okay?
How does this handle assets that the woman came into the marriage with, that she has an ironclad hold on it, that the husband only has access to the revenue from it as opposed to the capital value?
Well, she should make her own will. She should sign her own will on those assets, so that she basically is saying, this is what I want to happen with those assets after I die. If I pass away before my husband, then I want him to have everything. And she has to, that would normally be the Torah halacha anyway, that a husband inherits his wife. But let's say she doesn't want her husband to have everything. Let's say she wants some of her kids to have, right? And not her husband. So she's got to make all of this clear in her own trust documents.
But how does a secular court deal with the fact that she maintains title?
Yeah, she does maintain title, right? So first of all, that could be true according to Torah law as well, that she maintains title if it came to her independently of her husband. If, let's say, she inherits something during the course of the marriage, that those monies belong to her, and her husband doesn't have a right to them. Okay, so those things happen all the time. So then she has to make her own will. She has to designate what should happen with those assets before, when she dies. And then she should include this, because in the event that according to Torah law, she's giving it to people who are not entitled to it, or do not have priority to it according to the proportions that she wants according to Torah law, she should do this document, which basically says, I hereby give a value from my estate, which is larger than the entire estate, to so-and-so, unless my rightful heirs fulfill the terms of my will. Okay, all right, Rabbi Sai, have a wonderful Shabbos. We'll continue with the next halacha, which has nothing to do with wills and estates, but rather has to do with a pious Jew not accepting gifts. And we have a principle called Hasone Matanos Yichya, that he who refuses gifts will live a longer life, will live a happier life. We'll talk about that halacha Mirz Hashem on Monday. I want to wish you all a good Shabbos.
Shabbos, everyone.
You're all well, and
Shabbos.
looking forward to
Shabbos.
back
Shabbos,
with
everyone.
you.
Shabbos all.
Take care.